Hi, I'm Michael DelSignore. In today's video, I want to talk about the breath test challenge that's occurring in Concord District Court, and there's going to be an appeal this Tuesday in the Massachusetts Supreme Judicial Court. First, by the way of background, the Massachusetts Supreme Court decided a case, Commonwealth versus Camblin. And in that case, they said defense attorneys are entitled to challenge the source code and to determine whether the breath test that we're using, the 9510, is scientifically accurate. The Camblin case dealt with the 7110. That was the machine before we upgraded. So the challenge that's going on in Concord was basically a response to the Camblin case, where the Massachusetts Supreme Court basically found three issues with the machine that defense attorneys are entitled to explore. One, whether the breath test is scientifically accurate for alcohol. The alka test measures alcohol at a 9.5 micron level, and other compounds can be confused with alcohol. Essentially, is whether this machine is specific enough for alcohol to be scientifically really reliable. Another issue is whether the source code. In the Camblin case, experts found over 3,000 errors. Whether those errors make the machine unreliable. The government contended, well, any complicated source code is going to have errors, so that's a second issue the court identified in the Camblin case. And the final issue is whether the machine actually calibrates the known sample. It tests a known sample, whether the source code actually performs that test, that sample, as it's supposed to. There was an issue that the defense in Camblin raised that the government never responded to, and that was left out as the third issue. So what's going to be this? What happened was these cases were all consolidated in the Concord District Court before Judge Brennan back in August of 2015. There's probably about 500 cases there. And defense attorneys, they filed some discovery motions requesting 3 breath test machines, requesting dynamic testing. So what the judge did was he denied most of the defense motions. There's two issues basically. Draeger, the company that makes the breath test, wanted a protective order saying if experts are going to look at this machine, we want to make sure that they're not going to tell other companies how we operate our breath test. So that they created a protective order, and that protective order was so restrictive that the defense couldn't get an expert to sign it. We couldn't get an expert. So it's one issue that's going to be decided Tuesday, whether this protective order is permissible. The second issue is whether the defense is entitled to dynamic testing, and the company that makes the breath test machine doesn't want that type of testing because of fear of its trade secrets being revealed. But dynamic testing of a source code is the most reliable method to determine whether it's accurate and reliable. The judge essentially said, I find static testing sufficient because I want to balance the commercial interests of Draeger versus the rights of the defendant to challenge the machine, and he found that a static test is basically good enough. I think the Massachusetts Supreme Court's going to say that the defense is entitled to the best type of testing. They're entitled to have their expert look at the machine, entitled to static testing, and the court will probably find the protective order too restrictive to allow an expert to look at the machine without fear of being sued. When the court in Camblin decided that we're going to have a statewide challenge to the breath test, and the district court judge consolidated about 500 cases, they entitled a full and fair hearing. The judge in Concord isn't providing that. I think the Massachusetts Supreme Court is going to overrule them and allow most of the defense motions for discovery. That's not going to win the case. We still then have to have a hearing on the merits of the issue. The experts have to then testify that the machine isn't scientifically reliable, and that would probably be 2 months down the road. Another interesting development is that Boston then had a separate hearing. Technically, Boston's not part of the district court. So then a judge in Boston basically was faced with these same issues. He found that allowed a more fair protective order and allowed the defense access to the machine. So essentially gave the defense what we're trying to get from the Supreme Court. So the DAs in the BMC, Suffolk County DAs, have filed the motion to basically say that everything should be in Concord, to essentially end the separate hearing in Boston. On that issue, the cost of this litigation is going to be substantial. I suspect the Supreme Court's probably going to find some way to consolidate the two cases, given ultimately they're going to decide this. Any district court judge's decision is going to eventually go to the Supreme Court. So that's going to be decided Tuesday, those issues of discovery. What's more important, the rights of defendants, their Sixth Amendment confrontational rights or commercial interests, and what protective order should the judge have required, and whether this separate hearing in Boston should go forward. It's what's called a 211-3 appeal. It's a special emergency appeal. That'll be decided. That will determine how the breath test challenge goes forward in the future. If you have questions about this, feel free to contact me. My name is Michael DelSignore, a Massachusetts OUI lawyer.